Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about discipline of lawyers. Cases that should have gone to the Supreme Court of Canada, but didn't. Diane Lafond was a lawyer in Quebec who was ultimately investigated by the Quebec Bar for misappropriation of funds and other unprofessional allegations. In the course of her hearing, Ms. Lafond argued that she did not get a fair hearing because one of the tribunal members who heard her case became unable to act on the matter after the case had been heard. She argued that because the law requires that he who hears it must decide it, it was unreasonable to render a decision, and in particular to render a decision imposing significant sanctions against her without having the views of the tribunal member and all three tribunal members who had initially heard her case. She lost this argument. She applied for leave to the Supreme Court of Canada, and leave was denied. And this case obviously raises very important issues, because in one instance, of course, when you have a single tribunal member who ceases to be able to render a decision, a new hearing can be ordered because the person who heard the case can no longer decide the case. But what happens when there are multiple hearing panel members, particularly where legislation actually requires there to be a certain number of individuals serving on a panel? If that minimum number can't be met, then can the panel continue to act? And how does this change between administrative law, where the standards are lower and it's all up to a reasonable interpretation of the legislative body's interpretation of its own statute, versus actual law in court, where, for example, a court of appeal panel doesn't have a sufficient number of people to hear the case, or one person who heard the case cannot continue to act on the case any longer. These things are important issues, particularly because in a small panel of three, the views of one individual may potentially benefit somebody and help to sway the other individuals to an outcome that is more beneficial to the person facing the allegations. This has broad implications for the scope of administrative practices. We see a move in Canadian law towards more administrative tribunals, and even proposals in legislation that is currently before the House of Commons for debate about creating more tribunals. And because tribunals in this country are seeing the same problems that courts are having with being backlogged, does this interpretation make it easier to address delays in tribunal decision-making? And then in what circumstances can a tribunal member say that they're unable to act? And how does the inability to act actually get determined? All of these are important issues to the actual functioning of the day-to-day administration of justice in this Canada. And it's unfortunate that the Supreme Court of Canada didn't take the opportunity to hear this case and to decide what should happen in a tribunal situation where one of a minimum number of panel members is no longer able to act, and where the case has already been heard. Hopefully we don't see injustice resulting as a result of the Supreme Court of Canada refusing to hear leave to this case, or hopefully we see another case where the Supreme Court of Canada takes the opportunity to clarify this and help to streamline and make more fair administrative justice in this country. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada But Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.